Joanna, are you going to lead off?
Yes, yeah.
Okay.
I'll begin the
Go ahead.
workshop. Okay. Thank you, Mr. President. Today we're here for the workshop to address the proposal by Director Hanks, and we've labeled it the Committee of the Whole workshop. Just to give you a brief overview of exactly what we're going to address here today. First, a brief presentation on the Brown Act, just to give you an understanding of the underlying minimum requirements that we have of the Brown Act, also of the California Public Records Act. Part of Director Hanks' proposal is a committee of the whole on both the Brown Act and the Public Records Act. And so we just thought it would be helpful to have that foundational information to you as this discussion goes forward and as the workshop goes forward. Then also a very brief discussion on the Committee of the Whole, and then wrapping this, looping it around to the beginning of what Director Hanks' proposal is and the reason for this workshop today.
For the record, we've had that presentation on the Brown Act and the California Public Records Act every 2 years for the board and for management. Don't we do that as a regular basis every 2 years?
Yes, there are compliance requirements with the Brown Act, the Public Records Act, and also information on conflicts of interest.
So we do that as a
Yes.
regular basis?
Mhm.
Okay.
Yes. Okay, so we're going to start off with the Brown Act. Starting off briefly, the purpose of the Brown Act essentially is that the legislature has found that the board exists to aid in the conduct of the public's business. And it is the intent of the Brown Act that the board's actions be taken openly and that deliberations are conducted openly. So this kind of lays the foundation for the basis of the open and public meetings. All meetings of the legislative body, the board, shall be open and public, and all persons shall be permitted to attend the meeting of the board, except as otherwise provided in the Brown Act, and we'll get into those exceptions. Okay, so first, what is a legislative body? It's not as simple as it's just the board. It is the board as the governing body, but there are other legislative bodies that are subject to the Brown Act requirements. Newly elected members that have not yet assumed office, have not yet stepped into their position as the elected director, still must comply with the Brown Act at the point that they are elected. Appointed bodies, and this is fully appointed bodies. The board does not have any specifically purely appointed bodies that other public agencies typically have. Unless and I apologize because I'm just figuring it all out, the WCAB is all appointed, all of the members are appointed. So that would be an appointed body. There is overlap between some of these legislative bodies. So appointed bodies, every member of the body is appointed by a member of the governing body. Standing committees sometimes are also appointed bodies, but essentially what standing committees are a committee that is formed for either a general purpose or for such as like a continuing subject matter. WCAB would be farming matters and water matters, or for having a fixed meeting schedule. So it would just be a committee that's formed by the governing body that sets a meeting schedule for that committee. And then there's private organizations, and these are very rare, but they do occur, and it's a private organization that is either created by the governing body to exercise delegated authority by the governing body, or receives agency funding, and then at least one member of the board is on the board of the private organization and has voting power. And these are usually nonprofit organizations. They're also commonly within cities and counties where you have just various activities and you have a wide range of authorities and powers, and it's often difficult for a single board to handle those. One thing to know, a standing committee is also a committee, even if it's comprised of less than a quorum, if it meets regularly or if it meets on a specific subject matter for an extended period of time, it's still a standing committee, even if it's not more than a quorum. So what is not a legislative body of the legislative body of the local agency? An ad hoc committee. So this is different from a standing committee. The ad hoc committee has a temporary purpose. It's a temporary advisory committee. It's composed solely of less than a quorum of the legislative body. So no members of the public. It's just 2 members of the board would be an ad hoc committee for a temporary purpose. Advisory groups not established by formal action of the legislative body. So this would be, for instance, an advisory group to a single decision maker, or that's appointed by staff to address a specific matter and requesting advisory information, advisory recommendations to that board member or to the staff. Individual decision makers who are not elected or appointed by the legislative body. A good example of this would be, for instance, a meeting of department heads. They are decision makers. They're decision makers for their departments and matters that are handled by their departments, but they're not a legislative body. Meetings of department heads do not need to comply with Brown Act requirements. So what are Brown Act meetings? What meetings must the Brown Act requirements comply with? Regular meetings. These are your regularly set, scheduled dates, times, location meetings. Special meetings, they're not set, they're not scheduled on a regular basis, but they will be scheduled to address a discrete issue, and the board often has these meetings. And then emergency meetings, these are rare. These are held when prompt action is needed to deal with actual or threatened disruption of public facilities. So an emergency situation, these will come about. And then adjourned meetings, and these are regular or special meetings that are adjourned to a future meeting, so essentially continued. Exceptions to Brown Act meetings. So these are situations where the meeting does not have to comply with the Brown Act requirements. Individual contacts, and it would be a member of the board meeting with any other person. It could be a meeting with a staff person to get questions answered. It could be a meeting with your constituents. So individual contacts. Conferences, these are any conference that you would go to to get information either about IID's business or just general water conferences, electricity conferences, or a similar gathering of some sort, an informational workshop type thing would be the same. Board members can attend, and more than a quorum of the board members can attend. The caveat, though, is to not discuss the local agency's business. Once you do that, that's when you come into being subject to the Brown Act requirements. Community meetings, this would be a meeting by an organization to address a topic of community concern. Again, it's attendance is okay. It's the discussion of IID's business that would cause the trigger of the Brown Act requirements. Meetings or gatherings of other legislative bodies. So another agency's meeting, again, attend. Standing committees. Because standing committees are committees of the board, these are ones where attendance only keeps you out of Brown Act requirements. If it's a committee and more than a quorum of the board, and there's discussion of board members of the matter that's being discussed by the standing committee, then you really need to comply with the Brown Act requirements for both bodies, both the standing committee and the board. And then social or ceremonial events, and these are purely social, purely ceremonial, and again, it's attend, not discuss. Okay. So then there's other types of meetings where it's not always clear and it can go one way or the other depending on how the meeting's handled, either subject to Brown Act requirements or not. One would be collective briefings. These are required to be in compliance with the Brown Act requirements, and a collective briefing would be a staff briefing to the board that involves more than a majority or more of the board members. Retreats or workshops. These are retreats or workshops that are held by the board or by the agency. And if more than a majority or more of the board is there, it's subject to the Brown Act requirements. Then there's serial meetings, and these involve only a portion of the legislative body, but eventually involve a majority. And so the common examples are called the daisy chain or the hub and spoke. The daisy chain is when you have one member talk to another member, and then that member talk to another member, and eventually you have a majority having an understanding, a consensus of the minds without them all getting together at one time. And then the hub and spoke is when you have one person, it could be a staff person, it could be a member of the public, or it could be a board member, but speaks to a majority until eventually there's a reaching of consensus of the minds, even though not all persons, not all board members were in the room at the same time. So those are serial meetings, and though once you reach a serial meeting and it's not just a one-on-one, you are subject to the Brown Act requirements. Informal gatherings, those speak for themselves, but essentially, again, it's attendance. It's whenever there's a discussion of IID's business where you trigger the Brown Act requirements. And then technological conferencing. The Brown Act does try to, as law doesn't always, but the Brown Act does try to keep up with the technology and with the understanding that there is the ability to have a meeting even though members of the board are in different locations. There are specific requirements that must be followed when you do teleconferencing. For instance, the locations have to be identified on the agenda. Also, the teleconferencing number and code needs to be on the agenda. The location of the board members, whether here within the jurisdiction or at another location, need to be made available to the public. And not more than a quorum can be outside of the jurisdiction. Okay, agendas. Posting or noticing is making the agenda accessible to the public. The posting requirements, depending on what the meeting is, must be 24 hours of that full time if it's more than 24 hours. For regular meetings, it's 72 hours. For special meetings, 24 hours. For emergency meetings, it's as soon as possible, the media 1 hour before, assuming that you can get a hold of the media, depending on what the emergency is. Mailing, if there is a written request that is submitted to IID to receive mailing notices of all agendas, that must be complied with. That request can be made at any point in time and can be annually renewed by January 1st of each year. Non-agenda items cannot be discussed or action taken in general. There are a few limited exceptions, but in general, they're prohibited from discussion. California 2012 budget. So this is just to address what's going on today. There has been, as part of the budget bill, which was signed by Governor Brown on June 27th, and is Assembly Bill 1464. It's the Budget Act of 2012. There was suspension of certain mandates for the 2012-2013 fiscal year, and this is actually part of the budget. And two of those pertain to the Brown Act. Now, mandates are whenever the state is required to reimburse a local agency for certain actions that the local agency is required to take by law. But the law actually has to say that the local agency receives reimbursement. And there are two provisions in the Brown Act where that's stated. These pertain to the posting requirements, the preparation and posting requirements of the agenda, and also to documents that are prepared or produced or come out of or are in preparation of closed session. And typically that's also part of the agenda. The closed session items are listed on the agenda. So really this relates to just the posting requirements. Now there's been some misconceptions that what the budget did was suspend the Brown Act entirely, and that's incorrect. All that it did was suspend reimbursement of those items that reimbursement is allowed. It's for 3 years, a suspension of 3 years. It's not completely a surprise. The California budget has not had money to reimburse local agencies for a couple years now. And the suspension has occurred before. It was in 1990. So this is not unheard of. But a lot of local agencies had the misunderstanding that this was wider than what it really is, and that it was a suspension of many Brown Act requirements, if not all of them, and that is incorrect. Closed sessions generally. The purpose of the closed sessions is to avoid revealing confidential information that may, among other things, so this addresses a few key closed session items and the purpose of them. To avoid confidential information that would prejudice the legal or negotiating position of the agency in litigation or that's active or pending or anticipated. Compromise the privacy interests of employees, or provide information about public buildings or systems providing essential public services. So for IID, that would be water and electric services that may pose a threat to security of the buildings and the systems. Closed sessions generally. Agenda, so like open session items, closed session items must be identified on the agenda and they must be briefly described. There are what are called sample safe harbor descriptions that are in the Brown Act that are basically a fill in the blank. If you use these, then you're generally within what the Brown Act requires for closed sessions, but it's not limited to those closed session items that the Brown Act lists. Reporting. Reporting going into the closed session essentially is reporting what the description of a closed session item is and is done immediately before going into closed session. And then reporting after closed session is required for actions, if any, are taken in closed session. Now, the closed session discussions and any documents or anything relating to closed session that occurs within closed session is confidential. There can be layers of confidentiality that's involved in a closed session. However, it can be a little confusing at times, but a good example is a closed session relating to litigation. There's also confidentiality with regard to attorney-client privilege, and then there's confidentiality related to it being a closed session item. So there can be layers of confidentiality. Okay, specific closed session items would include litigation. Existing would be litigation that's actually occurring and it's in the course and in the process of being litigated. Threatened litigation would be if there's an actual threat to IID for litigation to occur that needs to seriously be taken into consideration and addressed. And then pending or anticipated litigation, which would be litigation that IID would pursue. Public employment would be an employee or an applicant. It doesn't have to be an existing employee, an applicant for an employment position. And it could be discussions regarding the appointment or employment of the person, performance, discipline, or dismissal. For real estate negotiations, this would deal with the purchase, sale, exchange, or lease of real property. And for public security, it speaks for itself. It's for issues related to public security of the systems of IID. But this one is unique in that there are no actions coming out of it that are reportable because that in and of itself would undermine the purpose of the closed session and of the discussion. Real quick, for public employment closed sessions, the board would need to have the power to appoint or evaluate or dismiss the employee in order to discuss the employee. So in general, the governing body of public agencies can't necessarily have a closed session about any employee. It's those that they have the power and authority over. And finally, we get to the remedies. There are 4 different possible remedies. One would be an invalidation action, which essentially just is whatever action was taken that is disputed would be an action to make that be reversed or dismissed, however you want to put it. But essentially that whatever action was taken is no longer valid. There's some limited actions that cannot be invalidated, but for the most part, as long as they follow the procedural requirements, that's a potential remedy. Civil actions, courts, essentially this is an interested party going to the court and asking the court to restrict or regulate what the board's future actions are. Some examples of what has occurred is tape recording closed sessions or prohibiting certain actions to be taken in open session by a court. And then costs and attorney's fees, the prevailing party can seek court costs and attorney's fees and recovery of those. And finally, criminal action, a violation would be considered a misdemeanor and would be handled and prosecuted as any misdemeanor would by the district attorney's office. And now I'm going to hand this over to Vance.
Thank you, Joanna.
Good afternoon, board members. I'll be taking the part of the presentation that deals with the California Public Records Act. Just by way of introduction, I'll talk about the purpose of the California Public Records Act, and I think it's succinctly stated under Government Code Section 6250. And that section provides that the legislature finds and declares that access to information concerning the conduct of the people's business is a fundamental and necessary right of every person in the state. So the interest, I think, is transparency. Availability, that's covered under Government Code Section 6253. Public records are open to inspection at all times during the office hours of the agency, and every person has a right to inspect any public record except as provided and to receive an exact copy of an identifiable record. Application. The California Public Records Act applies to all state and local agencies. A local agency is a county, a city, a school, a district, a municipal corporation, or a special district like the IID. What are public records? Government Code Section 6252 addresses this issue. Records include all communications related to the public's business, regardless of physical form or characteristic, including any writing, picture, sound, symbol, whether paper, magnetic, or other media. So it's not just paper records, it's recordation of board proceedings, recordings. The legal definition of documents is actually very broad in this instance. What is not included? Well, records not yet in existence. An agency cannot be required to create a record simply to satisfy a request. It has to be a record that already exists. It doesn't include purely personal records that are not related to the conduct of the people's business. An example might be a purely personal email. What's the process? Responding to a public records request typically has to happen within 10 days. And the 10-day period is so that the agency has an opportunity to review the request and to evaluate whether or not exemptions might apply. The public agency has an obligation to assist the requester to identify responsive records if that's necessary. With regard to the 10-day period, in some instances that can be extended in unusual circumstances. Basically, the public agency under, I'm not sure if it's 6253 or 6253.1, but I believe it says that the agency can notify the requester that up to 14 additional days are required to determine as to whether a request seeks disclosable public agency records. Well, what are unusual circumstances? They are defined under the statute. One is the need to search for and collect the requested records from field facilities. Another is the need to search for, collect, and appropriately examine a voluminous amount of separate and distinct records in a single request. Also, on occasion, there is need to consult with an outside agency. We actually had this come up recently in connection with a public records request that we got from a document that was jointly prepared between IID and SCAPA. So that one does come up from time to time. The last one is the need to compile data to write programming language or a computer program or to construct a computer report to extract data. Charges for records. There is a cost to public records, and unfortunately, under the statute, we're limited to the direct cost of duplication. Charges for search, review, and redaction are not allowed. And the citation on that is the North County Parents case versus DOE. IID charges 25 cents a page to cover the cost of duplication. The staff time, however, necessary to respond in writing to public records requests and to locate, compile, review, and redact documents can't be recovered. That's an expense that does have to be borne by the IID. In some instances, the public agency may withhold or redact a record. If so, the agency has to be prepared to justify the withholding by demonstrating that either the record is exempt from disclosure under Government Code Section 6254, or the public interest in confidentiality substantially outweighs the public interest in disclosure. That's under 6255. That's what they call the catch-all exemption. In other words, it was kind of difficult when the legislature put the Public Records Act together to anticipate, every possible situation. So I think 6255 is there for an issue that might not be covered under 6254. Where essentially there would be a balancing act that has to be performed, and the balancing act has to come out in favor of the public agency's interest in confidentiality. It has to actually substantially outweigh the public's interest in disclosure. Again, exempt records need not be produced by a public agency in response to requests for public records. The purpose of the exemptions is to allow the public agency to safeguard documents that, if disclosed, might compromise a legitimate public agency interest, or where production might run afoul of sound public policy. At this point, I'll go through some of the key exemptions. There are many, many exemptions, probably more than 30 or 40. And most of them are contained in 6254, but there are some other ones in other areas. But I'm just going to go through the ones that come up for us quite a bit. One is attorney-client discussions. Under, I think it's in the Civil Code, attorney-client communications are protected. And 6254K is under the Public Records Act, and that incorporates the attorney-client privilege into the Public Records Act so that you don't have to produce records that are confidential attorney-client communications. And the idea here is you want to encourage the clients of attorneys to make full and honest disclosures to counsel, and it also allows for open, unfettered communication of parties in an attorney-client relationship. The next exemption that comes up quite a bit is the deliberative process. Oh, excuse me. I think I skipped one. The deliberative process privilege is under 6255. Remember, we talked about that balancing act that has to be performed. In this case, the deliberative process privileges recognize that documents, if disclosed, let me back up a little bit. Documents which chill the agency's deliberative processes by revealing the thought process of the government decision makers. In other words, if you have a record that represents a final decision, that's not deliberative because it doesn't reveal the thought process of the public agency. But if you have draft documents or documents where you're leading up to a decision but you're not quite there yet, the legislature recognizes that the public agency has an interest in keeping those type of communications or not disclosing those type of communications. And I think it kind of goes with the recognition that we're accountable for our actions, not our thoughts. Two cases under the deliberative process are the Times-Mirror case and the Rogers case. I think in the Times-Mirror case, it was held that a governor's California governor's calendaring entries didn't have to be disclosed, and the Rogers case had to do with phone records. And basically what the court said is that these type of records provide a window of insight into the mind of the government decision makers, so they were properly withheld and exempt. Preliminary drafts, notes, and memos are also exempt, provided that the record is not retained in the ordinary course of business and provided that the public interest in withholding clearly outweighs the public interest in disclosure. And again, you have to engage in a bit of a balancing act to try and determine whether or not the public agency has an overriding interest above and beyond the need for disclosure. If the public agency interest doesn't substantially outweigh the public interest in disclosure, then it has to be disclosed. Pending litigation, another exemption, that's pretty obvious. You wouldn't want to give up your litigation strategy to your adversaries, so that's why that's there. Also, personal, medical, and similar files if disclosure would reveal intimate private details. That's another one that's pretty self-explanatory. there's highly sensitive information in a typical personnel file, and that's not something that the public should have a right to look at if it's embarrassing or concerns private details about the employee. Another one that comes up for IID is geological and geophysical data, plant production data, and similar information relating to utility systems development or market crop reports obtained in confidence from any person. That sometimes comes up in connection with the Energy Department because from time to time we do take geophysical or geological, geophysical plant production data, and we sometimes take those under assurances of confidentiality. So that exemption has come up as well. There's also 6254K, which essentially provides that any document that's protected under either state or federal law, you can withhold those type of documents as well. That kind of relates back to the attorney work product or the attorney-client privilege. Those are incorporated into the Act. And also our critical energy infrastructure. There are certain federal provisions that require us to safeguard and protect that information. And because of 6254K, we're allowed to incorporate those rules into our interpretation of the Act. Also, utility customer records, records that evidence the name, credit history, utility usage data, home address, telephone numbers of utility customers. That's actually protected under 6254.16. So that concludes the portion of my presentation that deals with the California Public Records Act. We've heard from Joanna Smith on the Brown Act, and that leads us to why we are here today in a workshop, and that's to discuss a committee of the whole. A committee of the whole specifically as to public records and Brown Act compliance. The first question I'd like to answer is, what is a committee of the whole? Well, technically, under Robert's rules, a committee of the whole is comprised of the entire legislative body, and it's created typically for detailed consideration of an issue under conditions of freedom approximating those of a committee. Essentially, a key feature is that the formal procedures for considering an item as it would come up on a typical agenda. You don't have those pressures of moving the item along. You can allow members of the legislative body to speak for as long as they want and to actually enter into debate about policy issues. So that's sort of what the committee of the whole is. And again, it's much like a committee, and it's designed to, I think, foster an open, unfettered communication for detailed consideration about important policy issues. The protocol for the committee of the whole is something like this. Typically, the legislative body would make a decision to commit a matter to the committee of the whole for debate, and they would do this by a vote of the legislative body to commit the matter to the committee of the whole. A chairman of the committee of the whole is appointed to chair the meeting or the committee meeting. And typically the president of the legislative body vacates the chair and allows another member of the legislative body to preside over the committee of the whole, so that the chair of the for the local agency can kind of stay in a position to maintain order when it comes time to go out of the committee of the whole and go back into regular session. And incidentally, you could go into a committee of the whole, I think, as part of a regular board meeting. You could also schedule you could block out a time on another day and do it that way as well, kind of like the WCAB and the ECAC does. After the chair is appointed, the committee then considers and debates the item at hand and makes advisory recommendations through the committee chairman to the legislative body. And then once the committee of the whole basically provides its recommendation to the legislative body can take a vote.
Isn't this kind of like a workshop?
Yeah, it's like a workshop or a committee. I mean, basically what you do is you kind of eliminate some of the procedural rules that might hamper an open, frank, ongoing discussion. There's not a lot of pressure to move things along because you're only dealing with one issue. And again, one of the key features of the Committee of the Whole is that it allows members of the legislative body to enter into debate. You can speak about an issue for as long as you can get the floor, and you can just focus on one matter until you get it resolved. And just kind of in my own mind, that's how I view it. Now, getting to Director Hanks's proposal, one of the things that Director Hanks asked for was to authorize the formation of an open meeting and public records committee of the whole. And I presume that, correct me if I'm wrong, Director Hanks, but you probably want that to look at the way we handle Brown Act issues and policy issues?
Yes, that's part of it. I've taken the liberty to meet with the newspaper editor, Mr. Delaney, and also Mr. Brown. And I encouraged them because they had made numerous requests for information and hadn't received it, had made comments about it and editorials and so forth. I encourage them to participate. Come and let us know as a board what it is that they're running into, what their concerns are. Likewise, we've also heard it from the public. And so I've asked Mr. Gary if he would voice what his concerns are as far as information that he's asked for, so forth. But the whole purpose is, at the end of the day, I would like to see us take a look at what the letter of the law says is one thing, and you guys have done a good job of showing what the letter of the law is. But what is the spirit of the law? What are we missing in our community that we have this dissension because information isn't being discussed, decisions are being made, some know about it, some don't. And so at the end of the day, what I'm looking for is some type of agreement or process and moving forward from here, how we organize policy that either enhances what the letter of the law is, or at least gets enough information out there that we feel comfortable that we've had a discussion. The public knows what's going on. They've heard the issues, the facts, the data, and had an opportunity to comment about it. But that's the purpose. At the end of the day, how do we get to that point?
Yes, and I think the Committee of the Whole, I did a little bit of research before today's presentation, and I've seen in other areas, like for instance the Regents of the University of California, I've seen some things online where it's shown that they've gone into Committee of the Whole for the specific purpose of taking public input. So, I mean, even though the Committee of the Whole would be comprised of all of you board members, it would obviously have to be a public meeting, and during any discourse that you would engage in during the Committee of the Whole, I think the public would also have an opportunity to participate. So I think it could be useful in that way. And I think what Director Hanks is talking about is what they call a sunshine law or a policy. And basically what that is these rules that we've talked about, as Director Hanks mentioned, reflect the letter of the law, but that doesn't prevent the agency from going above and beyond what the law requires. You might give special treatment to certain classes of documents that aren't very controversial. I mean, like job descriptions or things like that. You can put limitations on, how you want to use exemptions. So there's, the board does have the ability to, as a matter of policy, determine that it wants to make records even more accessible than is required under the Act. So that is something that could be done, and I think it could be done as a Committee of the Whole.
I think to get to that point, Mr. Taylor, there are some questions that I think we need to have discussed or answered today. One, what is the purpose and the value of the Freedom of Information Act to the organization and to the public? what is the purpose of it? You know?
Well, I think it's transparency. I think the government recognizes, and just about everybody else, that we're serving people, ratepayers in this case, and they have a right to know what's going on, with some, reasonable, I think, limitations, to the extent the public agency has a legitimate interest in maybe maintaining some confidentiality. But I think without question, transparency is the overall goal of both the Brown Act and the California Public Records Act.
Well, I think part of it is also accountability. I think that part's been missing. And also, I think for the public to be informed and to help formulate decisions and help us determine best business practice, they need to be informed. They need that opportunity to engage. And I appreciate what Mr. Kelly said today on the bid process. That's an example. It was very challenging. It was very volatile when we discussed it, and it shouldn't have got to that point. Okay, so now we're making adjustments and continue to make adjustments. But that's an example of what I'm talking about. Once the public had an opportunity to have their say in the matter, that it was almost like it had to become explosive before we really settled in and discussed it.
Mm-hmm.
The other, there's been accusations about corruption, and I think that gives the organization a chance to defend against it. If it's been discussed, if those things are brought out and they are discussed, I think it puts a lot of that at ease, or it might enhance it too, But anyway, it helps an awareness factor there. There's a fine line, I think, or I think where our issue is that fine line between the letter of the law and the spirit of the law. If you go to the letter of the law, then quite frankly, the attorneys, they understand that, and they know how to defend against that, and that gives one up to whoever has an attorney. But to the public, it's the spirit of the law that matters, and that spirit can be met with participation, and still respect, especially if they're aware of what the exemptions are.
Mm-hmm.
And the the exemptions you have put up there, but there's also a statement when information is prejudicial against the public's interest. Who determines that? What does that actually mean? The public interest may be somebody's political viewpoint or someone's ideology or concepts or whatever. But there needs to be some type of mechanism how we set that as a policy or define it, or how does the community view that issue? Because if you listen to public comments, the public's interest is all over the board. And then another one that's a big one for me, and that's a definition of attorney-client privilege. In the form of communication. Does that mean just because a person is an attorney, he's forever protected in any of his communication? You can't disclose them? Or is it, when we're talking about a client, is the board the client? I've discussed that several times. In my viewpoint, the board is the client. So if there's attorney-client privilege, then we all should be privileged to it.
Well, generally
It's
speaking,
not, it's a personal, then our legal team is maybe providing legal service to an individual instead of to the organization. So that one I think needs to be discussed. And then the issue of the business communications, that's ongoing. That really needs to be defined. I think it's very important to the board, as board members, that we have a full knowledge of when our communication, whether it might be with somebody that's controversial in the community, or it might be just personal, and an emergency health issue from home, we get on our BlackBerry or something. There needs to be a full understanding, not just from the board, but from the public, so that in doing the public's business, we don't have these misunderstandings or lack of participating within the same rule set. And then the last one, and I don't know quite how to word this, but in California, we've come up with different rules over time, and it goes way back. But I understand that we represent the public. I understand that we make decisions on behalf of the public. But the public still has a right to participate. Just because we're an elected official doesn't mean that the decision making begins and ends with us. Okay, and then I have some other issues, but that I like to discuss, but I'll save that till later. But I think that's the key to where I wanted to go today with this workshop, or this committee as a whole. How do we come to some type of agreement, how we're going to handle these things? There may be times when information that may be public information is not let out because it may be embarrassing. Lord knows I have some emails that would be embarrassing. Okay? So I'm not talking about everybody else, I'm talking about myself too. But what are those rules? When do they apply? And if we have a good knowledge, we may want to decide how we handle our personal business, where it kind of overlaps sometimes in conducting the public's business, because we're not confined to just our division. You can't just have an office in your division and you're there and meet and greet people. You're all over the Imperial Valley. I probably get more calls outside of my division than I do inside. So I think that would be helpful. But that's where I wanted to go with this today.
If I can, Mr. Taylor, if you could, isn't it fair to say that the board right now in this called workshop is acting as a committee of the whole?
in a sense, I think so.
And it's for this specific purpose, this issue that has come up as a matter of course that you want to deal with in a specific way. And in the interest of disclosure, you did meet with the newspaper.
Yes, that is correct. Mr. Garber and I, we had lunch with Mr. Brown and the editor of the paper as well.
Yeah, I think that resulted in a Sunday editorial.
Actually, this was, I think, on Thursday of last week. I found out about it the day they went.
I think there was some communication before that you're not aware of.
It could very well be, but the reason we talked about this yesterday at a staff meeting, just so I'd know generally what they were saying, or what they were going to say today. Not that I wanted to have exercise any undue influence over it. It's too late for that. But as the board knows, in a prior capacity, I was in the journalism business. There's no more ardent advocate of First Amendment or full disclosure than I am. I've always believed that it's probably the quintessential right that we all enjoy as citizens. And as I understand it, the acid test for the legal department is whether or not the public interest, the public's right to know, is trumped by the agency's right to conduct its business. And that's a very high threshold. As the board knows, the IID is literally beset by CPRA requests, many of them sweeping for every email that has ever been issued for multiple years. Clearly, you know, to comply with that, it's not just, you know, what's in them. It's will you ever want to correspond ever again? So you will have a chilling effect on the business of the district. And that may well be that may actually serve a legitimate public interest, but it is an acid test that has to be applied.
Yeah, could Mr. Gary address us at this time and then hear his input and then rotate back around?
I would like to make a comment, you know, in the interest of transparency and so forth. According to the agenda, it doesn't state Mr. Aguirre as a presenter. I was very surprised when I got your presentation, Mr. Aguirre, and we're talking about Mr. Hanks, about transparency and openness, and I just got your I didn't even know you were going to be here. So,
Well,
no, it's not going to be an issue, but you're not even listed on the agenda. So I'm all for being open and transparent, and let's all work together. But I don't like surprises.
Well, can I address that?
Yes, please.
I think you probably got his before you did the one from the IID.
No.
I don't want to start off.
Mr.
No,
Gary, state your name for the record, please.
Oh, yes, Mike Aguirre. Thank you very much, Mike Aguirre. I don't want to start off negatively, so let me just say this. Give me a chance to just go a little bit into my presentation, because I think I can show you exactly why you should not be upset.
I'm not upset. I'm not upset at you. I don't
Okay.
even know you. I'm just saying that you're not on the agenda, and here you are making a presentation.
In the committee of the whole, there's not really an agenda. There's a subject matter, and the idea is to loosen it up so you can have a discussion. But I'm sorry that you didn't know. But as you probably could see, I spent a lot of time getting my thing prepared, and I would like to present it to you, and hopefully you'll find it of some interest.
You have a lot of pictures, I can tell you
Well,
that.
I think that there's something more in there than pictures. But if we can go to the actual presentation, because you know, one of the things that if you'll go to starting the show, there you go. It would be a mistake to focus on the black letter law, and I'm not talking about spirit of law versus black letter law, but it would be a mistake to focus just on the black letter law until we get a very deep understanding of the principles that give rise to the black letter law. And in the first slide that I wanted to show you, the next slide, if you would be so kind, I guess, Yes, thank you. California, unlike the federal government, is what's called a direct democracy state. In other words, if in our federal system, our government is a representative form of government in which we elect officials, and then those officials make decisions. But there is no such thing in the federal government as initiative, recall, or referendum. So one of the fundamental differences in California that the IID, ironically, is tied very deeply to is the concept of direct democracy. That means the citizens actually play a much more robust role in the decision-making process. If we can go to the next, please. Direct democracy. I think you'll all probably recognize where that is. Direct democracy means that citizens can come forward and they can initiate the law. They can actually pass a law by themselves and not even go through their legislative body, the city council. That's a tremendous power. We don't have that at the federal level. Even though the federal government is a government of limited authority, the citizens retain the ultimate sovereignty, but they do not have the right under the federal Constitution, the United States Constitution, to initiate the law. If we might go to the next, please. Direct democracy. These young people, graduates from El Centro High, when they turn 18 years old and they register to vote, they have an absolute right to go to the state legislature or their city council or the board of supervisors or the IID and witness and participate in what's called your collective concurrence. When you collectively concur, when you have a group discussion, these young people have an absolute right to participate not only in listening and watching you about how you make up your minds. You're not supposed to make up your mind outside this chamber. And I don't mean you personally. This is true for our democracy as a whole. You're not supposed to have discussions with each other in a roundtable way in which you collectively concur. So by the time you come to the meeting, it's a ceremonial event and not a decision maker. If we can go next, please. Sometimes the people that are involved in direct democracy are very controversial. Sometimes what they're asking for is very divisive. And the whole theory of our direct democracy form of government is to give them an opportunity to turn into law what their policy objectives are. For example, because of Cesar Chavez, who was a client of mine, and Helen, the farm workers were able to get the agricultural laws changed in the state of California, and they were able to get secondary boycotts approved, and they did that through mass action. That's direct democracy. If we can go next, please. Now, who started all this direct democracy? It's that little guy right in that car right there whose name was Hiram Johnson. He was a Republican, and he was also Theodore Roosevelt's vice presidential nominee when the Progressive Party ran against Taft and Wilson in 1912. And this is a picture of Hiram Johnson, our former governor and our long-term senator, arriving at the nomination. He was a national progressive figure. He had a massive following in California. He was one of the most popular of all of our candidates. And for our brothers and sisters in the Republican Party, they can take great pride in the fact that it was out of the Republican Party that the progressive movement came, and they elected this outstanding governor and outstanding senator and vice presidential candidate, and he's the one that got this started. If we can go next, please. All right. In 1910, Californians adopted the initiative, the lawmaking power, the referendum, the ability to overturn any decision that any legislative body makes, and the recall, to actually vote someone out of office. Those were the three linchpins of Hiram Johnson's campaign for governor, all of which was directed at the Southern Pacific Railroad at the time. And the fact that the Southern Pacific Railroad was so powerful and so anti-public interest. If we can go next, please. Now, you began at the height of direct democracy and the movement for direct democracy. Your organization is an outgrowth of direct democracy, which I was really surprised to find in doing my historical research. I used to teach history at the University of Southern California, and I love history, and I love your history. It's a fabulous history. And you arise out of direct democracy. And in a sense, I'm really not urging you to do anything new. A group of citizens got together. They put together a proposition. Their neighbors and friends and family and supporters voted it in, and you were created. And you were the product of direct democracy. Please, next. There's some direct democracy participants right there. I'm sure you recognize them. Some of the original leaders in the 20s of this fabulous organization. People that sacrificed and worked hard and discussed and debated amongst themselves and hammered out a policy many people thought was impossible because of all the flooding. And they made it happen. But they made it happen because they participated, and they had lots of people that participated with them. Next. Now, this is the point, probably the most central point, that if I make any point with you today, this is the point that Socrates made, but it's really just an observation. In the Athenian Assembly, when the discussion was about matters of general concern, the persons who rose to advise were all treated equal. And it was for this reason. The Greeks believed that when it came to general government policy, any citizen was as good as any other citizen, because the primary attribute, the primary virtue of a public official was common decency. That most decisions required the person to call upon the common concerns that they had for one another and their common values. And so the idea was, in Greece, they rotated public office amongst the citizens in the same way that we rotate jury service amongst our citizens. Yes, when they discuss complex issues like some of the complex issues that you discuss, and you are all obviously experts in those fields, the common is not helpful as the expert is. And the Greeks recognize that as well. So the idea that you're trying to advance is that you are the ultimate decision makers, but you get the advantage of taking into account everybody's point of view. And that's the strength of your position. The more you get public involvement, the more you get a cross-section of the community appearing and participating in your process, the more powerful you become. Because you are now harnessing the collective capacity of a community and not just one special interest. But you do retain, and you have the exalted position, the position of honor, the highest position that you can hold in democracy, which is to become the ultimate decision maker, the ultimate concurrence of what is in the public interest. And you ask, who determines the public interest? You do. Why? Because you're the elected officials. People can come in and ask you to consider this and that and another. But you are the ones who determine ultimately what the public interest is with your vote. Yes?
So when you're saying, what you're saying is that when this board was governed by a full board of the farming community, it was not a good board?
Well, I'm not saying
Because for many, many years, this board was held by members of the farming community. So what you're saying, that was not good?
Well, I was saying that if they did not take into consideration the common discussion and democratic input, then no board that does that is good, whether it's a farming board or any other board, because they're not achieving the values and the ideals. Next, please. Okay, now, it's not the spirit of the law You make the law. You are law makers. When it comes to what kind of access you want to have, the Brown Act and the Public Records Act, which I'll show you in just a moment, they set the minimum standards. But you set the law. Your policies. You can adopt a set of policies and you can work it into your bylaws or your charter. You can make it as strong as you want. And the idea is to think through, that I'm urging, is to think through how can you make your system so that every time a decision is made of any importance, you can draw upon the strength of the entire community and get everyone involved. Knowing that no matter what they say or don't say, you're the ones that are going to finally make up your minds about what to do. And that's your democratic right. It is important for you to make those decisions because of the democracy decision, the democratic decision to install you in your positions, as it is to do any of this other stuff. It's equally important. Next, please. Okay. Now, this is going to sound a little straightforward, but let's be honest about what the Brown Act says in its preamble. The people remain informed to retain control. Ultimately, who are the ultimate decision makers? The people. Why? Because they have to evaluate what kind of job did you do. So if they are not informed about what kind of job you did, then they can't retain control. And in our democracy, in our direct democracy, that is the goal, for them ultimately to retain control. The only reason you exist, well, I know that my brother was talking about the agency versus the public. There is no distinction. There is no agency. There is no public.
Who's your brother?
Right here, my friend right here.
Oh.
There is no distinction. The agency is the public and the public is the agency. The only reason that the agency exists is to aid in the conduct of the people's business. That's what the law says. Now, one thing I would like to do before I leave is Ralph M. Brown was a fabulous assembly member. And in 1953, he held a series of hearings, and I have the report, and I'll leave it with counsel. He held a hearing, or a whole bunch of hearings, and one of the things that he involved the governor at the time was Earl Warren. And at the time, Governor Warren said, there is a tendency in all levels of government to withhold information from the public because it might be embarrassing. I have found it necessary to fight the trend in my own state administration. It is the duty of every public executive to do the same thing. Embarrassing, yes, but that is not an excuse not to return it unless it does involve personnel matters. Now, in this report that was done in 1953, Assemblymember Ralph Brown said, quote, "The suppression of public information by government bodies and officials is not of recent origin. A struggle against this infringement to our liberties has been waged since early colonial times. Benjamin Franklin, as a newspaper publisher, knew of such acts and took a part in fighting their restraint." In other words, it's not just you. It's a natural tendency. People don't necessarily want to share all the information for a lot of understandable reasons. But part of your public responsibility, when you raised your hand and you took that oath, was to commit yourself to serve in a public position. Thomas Jefferson said public office is like public property. And sometimes you have to think of yourselves that way in terms of it's not your private business, it's not your private agendas, and I don't mean to offend you in any way, but you should not take offense because as far back as colonial times, this has been a perennial problem. Next, please. Oh, I'm sorry, before we do there. The IID does not have the right to decide what is good for the people to know and what is not good for them to know. That's really, in other words, they don't need to know that, or they do need to know that. You have a right to set the policy, but the standard that you use can't be because you think they should or shouldn't have that information. Now, the IID is required to act and deliberate openly, and I've talked about that. And the reason is that that's what they call collective concurrence. And if you think about it like this, if you're sitting in your office by yourself and you're writing something out and you think, I'm going to write this, and you think, no, I changed my mind. That's protected. Why? Because we want you to be able to consider in your own thinking whatever you want. And no one can come and rip that out of your hands and say, you know, we must know what you think, because maybe you thought one thing one day and then you didn't make up your mind and you thought something different the next day. That's protected. And the concept there is that we want you, that is, we being the law wants you to be able to have that kind of prerogative. Now, once you start calling each other and discussing the issue, then the decision-making process is starting to advance. Once the decision-making starts to advance, that's when what they call collective concurrence takes place.
Mr. Aguirre, Mr. Taylor already talked about all that, serial meetings and all that.
I'm not going to talk about serial
that.
meetings.
We already know that. So,
Okay, all right, well,
so
then that's
continue
okay.
with your presentation,
Okay, very good.
please.
Okay. Now, okay, let's go to the next one then. We'll go to the next. Okay. What is the purpose of the open business? Facilitate public participation in local government decisions. We've already talked about that. But here's one that's equally important. Secret legislation. Has IID ever adopted any secret legislation? Have there been any decisions made about any of the important issues that have really been where the collective concurrence has been behind closed doors? I mean, I think if you examine, the case, there's argument to be made.
I didn't know about this till just right now.
But Ms. Mendoza, there's a difference between secret legislation, which is not before you, and having a committee of the whole in which all citizens have an opportunity to participate. So
not to my knowledge.
Let's keep going with that a little bit further. A committee of the whole is an opportunity for everyone to discuss things.
And I think it's a great idea. I'm not against it. I think it's a good idea.
Okay. What secret legislation is when, let's say, two people get behind closed doors and they decide what they're going to do something with the QSA. And then they get a third person to go along with it, and then they go to the meeting and it's just a ceremonial event. I'm not saying that happened. I'm just saying that that's something that could be called secret legislation. And that's what they're talking about, not citizens coming before you at a committee of the whole to talk about adopting better practices and procedures for the Brown Act and the open meeting law. Go ahead, please. Okay. Now, the open meeting law, and if you say that you've already gone through all of this.
Yes, we have.
Okay, so you've already discussed the fact that meeting-related records have to be provided right away. You've already gone through that. That was mentioned.
You should give them a copy of your.
Okay, that's fine. Then let's skip this, and we'll skip those items and go on to the next. And this is the section, I want to just mention this. Thank you very much, Council. Allow greater access to their meetings than prescribed by the minimal standards. So, what does that mean? Let's say that when you're in closed session, you ask yourself, before you go into closed session, you state what your closed session agenda is, and this is the rule that we adopted in San Diego. You state what your closed session agenda is, and then you have a discussion before you go into closed session, or at least you give folks the opportunity to try to persuade you that it doesn't need to go into closed session. Really, the only real reason to go into closed session, the fundamental reason, is to protect the public interest. If you're negotiating a contract or you're trying to settle a lawsuit, it's not in the public interest for the people that are adverse to the city, or in this case, the IID, to know what it is your point of view is, because then that weakens the position of the agency. But let me give you an anomaly. Under the rules of professional conduct, for lawyers, clients cannot speak to the lawyers on the other side of the case unless the clients have their lawyer present. Not so in public agencies. In public agencies, what happens, and I don't know that that's happened here, but from time to time what will happen is clients of the public agency, without their lawyer present, will have conversations with the people on the other side. And that can be a very problematic situation. So that's something that let's go to the next one, please. Okay, and I'll get through these quickly. Go ahead, next. Okay, now this is something that's very important. I did not hear this during the discussion. Access is a fundamental and necessary right. It's not all the exemptions and all the rest of it. But this is a fundamental and necessary right.
And I agree with you.
Okay, well, let me just say, in my own personal experience in trying to get documents, I don't think that was really what was happening is the attorney-client privilege on documents that were routine documents were shared with attorneys, and then the attorney-client privilege was used as a blanket shield, okay, as a blanket shield. For example, we still don't know, when the gentleman stood up here years back and talked about release of water into the Salton Sea, and then that's turned out to be what happened a few weeks later, we know nothing about how that came to be. There's been no public records disclosures, and there are tons of public records, and all of them, 99.9% of them, were withheld because of attorney-client privilege. And I don't say that to bring up an old sore. I only bring that up to have you think about the fact that there's been a drift towards a policy regarding public records that they're not shared. And frankly, the reason I came here, and I mentioned this to you before, is before I decided to even get involved, I wanted to test your system to see, are you an open system or a closed system? It was the most closed system I've seen of any public agency, period. And I've been working with the Public Records Act and the open meeting laws for the last 30 years.
Mr.
Next, please.
Aguirre, who hired you to come here? Are you coming here on your own free will?
I'm coming here today, all by
Nobody,
myself.
no one
Not
is
one
paying
person,
you
nothing.
or
I'm
your
just here.
assistant?
Not my assistant either. No, she's not my assistant. She's my law partner.
She's your law partner. No
Yes.
one pays you to come here?
No. Can you believe it?
On your own, you're here on your own time?
Own time.
She was here the other day with
Same
another.
with her, too. She didn't get any money. Isn't that amazing?
So
Unlike you,
I can't believe that.
I know, unlike you, who is being paid to be here.
I can't
I'm here and I'm
believe-
not even being paid.
I can't believe that.
Well, you know
All
what?
these-
That's the truth. That's how life works.
And a year ago, when you were here having meetings and so forth, nobody paid
Well,
you
I
to
wasn't
come?
here a year ago having meetings,
Yes,
but
you were.
well, I was here. No, I wasn't having meetings a year ago.
Well,
I
you
was
were here meeting people, I know.
No, I was here in court, but I wasn't here meeting any people.
And, and you were getting paid at that time.
No,
I'm
I
sure.
wasn't, and there's wrong too. See?
Really?
I mean, how can you make statements like that? Miss Mendoza.
Because lawyers don't do
wait, hold
anything
on.
for free.
You made it. Wait a minute. You made it. What? No, what?
Lawyers hardly don't ever do anything for free.
Well, Miss Mendoza, I worked for the United Farm Workers Union for free.
Well,
I-
I commend you for that.
Okay.
And for that, I thank you.
Okay, and I appreciate that. But you know what? I know I got a ways to go to get your trust.
A long way.
Okay, but if you knew who I was and what I've been through as an attorney, you would find that there are many cases that I work on for free, and this is one of them. Okay, I'm engaged in this because I came out here on my own, not paid by anybody, tested your system, and I was surprised. I see this. I have my own point of view about what's happened here, but what I've elected to do, and I appreciate the opportunity, and I'm almost done. I've elected to try to persuade you, be the best. You have a chance to be the best. If we can go to the next, and I'll show you how. We'll skip this because I think that you've already been through that. And again, you can adopt better rules. Go ahead next. Okay, California where? We're talking about public forum law. Public forum law. Terry Frank. Terry Frank is the #1 person in the state, in my mind, for public records and open meeting law.
That's the California Newspaper Publishers Association.
But Terry Frank is the person who I deal with there, and he's the person who I know is a very, very solid individual because I've used him myself in helping to try to think through San Diego's policy. In San Diego, what we did is we amended the charter when they amended the state constitution to strengthen the public record law and to strengthen the open meeting law, and we put that in our charter. But I want you to focus on this area, public forum law. Public forum law. That's a particularized area of the law, and there's not that many experts in it. Terry Frank is one of them. And what he basically can do, and what I urge you to consider him for, is to come in and meet with you, be a part of your committee of the whole, and then you give
For a
him-
fee, right?
Well, usually I think that you'll see that let's put it this way. I would say every dollar you spend on Terry Frank in terms of getting the public more involved will have a return of 10 times that amount. Because the way that you all have been spending money here,
You know, Mr. Aguirre, the IID gets criticized for spending all this money on attorneys and consultants, and you're standing there telling us to spend more money on more attorneys.
Well, I think what I'm telling you is to listen to what he has to say, because I think that some of the decisions, had they been made in the open, that you've lost millions and millions of dollars on, that you would have saved a lot of money.
And we have to spend millions and millions because gentlemen like Mr. Morgan keep suing the district.
Well, no,
and
no,
we
no,
need
no.
to protect ourselves.
Wait a second. Hold on a second. Mr. Morgan and the others who have come forward to present their case to you, there's no reason that you and they can't sit down and try to work that out. It takes two people to fight. It takes two people to withhold. But I would say this: the amount of money that you've spent or lost with regard to the QSA and the obligations that you've undertaken by letting the state off the hook and doing that in closed session.
I won't discuss
No,
that
but you
with
raised
in
this up.
open-
No, wait,
that's-
you
that's
you raised the issue. Let's
I'm sorry I did.
Okay,
I won't
then I'll back
discuss that
off.
with
Okay.
you in open session.
Okay, then I'll back
But-
off. But my point to you is this.
And you should know better than that. You're an attorney.
Well, no, I don't know better than that. I think what
Good.
I said is true, and I am
But
an
you should.
attorney, and that's the
Okay,
reason that I'm saying
continue
it.
with your presentation,
Okay,
please.
now, what I'm saying to you is this. I would bring Terry Frank in, and I would let me say this. I urge you to bring Terry Frank in and have him have a discussion with you, and you tell him that you want to have the best practices when it comes to open meeting law and the best practices when it comes to public record law, and ask him, who would he go to? Who would he look to? What policies would he recommend? And I tell you that for this reason. If you do that, you could put the IID on the map. You could go from an agency that has been beset with conflict amongst your brothers and sisters in the community to an agency that says, you know what? Everyone has a right to rise to advise. Whether they're a farmer, whether they are a farm worker, it really doesn't make any difference. And if you do that, you will so enhance your position, and you will so change the corporate culture that you will achieve greatness. And it's possible. I believe the IID is marked for greatness. I believe that you do have the people, the staff, the personnel, the know-how, and the strategic position, by accident of history in a way, but as a product of the direct democracy of those who came together and started your organization in 1911. You have a chance for greatness. And the first step to achieving that greatness is to have a rebirth of freedom. Last one, please. I love this line from Abraham Lincoln. After he goes through his 3-minute presentation, and he says that this nation shall have a new birth of freedom. That's what you need at the IID, a new birth of freedom, and that government of the people and by the people and for the people shall not perish from the earth. That's what we're talking about here.
Damn, I never knew I wasn't free.
You didn't know that you weren't
No.
free? Well, you may not be, but the people that come before you, I believe, feel that they're not free. And it's their interest that I think that we have to be focused on, that this nation shall have a new birth of freedom. And I say that to the IID. I appreciate, Ms. Mendoza, that you are someone who stands up and does what you think is right, and I commend you for
Mr.
that.
Aguirre, I appreciate your presentation, even though I still fail to see what it had to do with the 3 bullet points that we have. But I would like to invite you at a later time, sit down, have a cup of coffee. I
Absolutely.
would like to get to know you better.
You know
really
what?
would.
My prediction is we're going to become the best of friends. You'll be surprised.
Oh, well, but we'll see. But I will have a cup of coffee
All right,
with
very
you.
good. I'll take you up on that. And thank you so much, Mr. Chairman. I appreciate it very much. Mr. Kelly, thank you very much. Council and members of the board, thank you.
Thank you
Mr.
for
Gary.
coming.
Okay, Mr. Kelly, how do you want to proceed?
Just before I forget, Terry Frank is is a well-known First Amendment lawyer. I don't know if he's still engaged in. I don't know if he's still the attorney of record for California Newspaper Publishers Association, but the IID probably the board and public would benefit from a brief refresher on public access, public's right to know, sunshine law. And is Mr. Aguirre still here? I'm surprised, Mr. Aguirre, in your local history there, that you spent all that time on Hiram Johnson and you failed to point out that he was the co-sponsor with Phil Swing of the All-American Canal legislation.
Well, thank you for saying that. I did not even know that.
And you taught history at the university.
A history
How
of-
could you have failed?
Well, you know what? There was my inadequacies, and I hope
I
to
don't.
make myself
The
stronger.
only reason I bring it out is that I was interested that
Right.
that you.
I'm glad that you said that.
And the
I-
other thing I would ask, since this is an open exchange, do you plan on issuing any more reports?
I don't think that. No, I think we've issued the last report. Right. I think that went about as far as the utility of that report. I think was it played its role, and I think that we'll find a better way to communicate with the IID.
Fair enough.
And I talked with Mr. Terry Frank yesterday, and I told him about you all, and he was intrigued. He was intrigued. He hadn't really been involved in IID before personally, but I think you'll find him, Ms. Mendoza, I think you'll find him probably more interesting than me by a long shot, and you'll enjoy him.
Mr. Aguirre, when I meet you for a cup of coffee, I will give you my copy of the first 100 years history of the IID, so you get to the
Autographed?
correct facts.
Autographed?
Yes, just for you.
Let me tell you something. I love that history. I love those pictures.
So you have a book. You already have the book.
I don't have it, but it's online, and I've been through it so many times.
I
I'm
will
enthralled
give you
by
a
it.
copy.
I want a copy with your autograph on it.
Sure will.
Thank you.
Okay.
That's all I have.
Tony, did you have a comment?
And maybe I'll have as much time as Mr. Aguirre got, since there's no 5-minute limit. In the advertisement in the newspaper, nothing was said whether Tony Ramos was going to speak here or Mike Aguirre. So they're surprising because it's almost like Ivy First put him here to speak for them. Under the guise of transparency, under the guise of openness, under the guise of direct democracy and progressiveness, when Ivy First is nothing for that. That's the problem I have, JP, and board members and the public. Look at the people that are here, people. Everybody here, 90% is hired by ID or hired by someone, except me and maybe Mike Morgan. It's either the newspaper, the guy taking the movies, people in the IID, but where's the public? Yeah, apart from you then. Apart from you, I'm sorry. Apart from you, I'm glad. But ma'am, I had never seen you here, so excuse me. And I'll tell you right now. But what I'm saying, there's no other public members. There's no other. And if this is meant for the
Mr.
public,
Ramos,
where is the
I
rest of
think,
the?
I think you answered the question.
What?
I think the reason they're not here because they probably gave up on us.
Well, I think they gave up on you too because sometimes people speak in forked tongue. They speak about progressiveness. They speak about.
But we're letting you participate.
Yeah,
America's
but-
great, and
but-
I've got some more to finish up if we could move along.
Let's
Oh,
let
you
Mr.
know what?
Ramos.
You didn't
No,
interrupt
let's-
Mr.
Mr. Ramos has
Aguirre.
his time.
Why are you interrupting me? Because he's on your side.
No, he's not necessarily.
Yes, he
on
is
my
on your side. And if you let me finish, because you don't like what I hear, you like what he heard, you didn't interrupt him. Let me finish, please, Mr. Hanks.
Have at it.
Well,
I've been pretty patient with you.
me too with you. And remember who's on top. Okay, you're only as good as your last election. You don't like to hear what I got to say.
No,
Right now, Mr. Aguirre said, people, wait, I'm not going to get in an argument
I
with
like
you.
what you have to say.
Wait, he said
But don't tell me
that
I speak
people
with a forked tongue.
that people that create problems are the ones that are progressive, like John Kennedy with Cesar Chavez there. He was very outspoken, okay? And if you refrain from interrupting me, I'd appreciate it, because the problem right now is you. The thing is here, JP and Stella and board members and public, is that what members of the public are here besides a handful of us, you know? And if Mr. Aguirre speaks eloquently, I'm not an attorney, but I'll tell you what, I am an attorney for God because I sponsored God, no matter what people say. And I don't need a degree to sponsorship, and I speak with my heart. All this about this guy, Terry, what was his name? Terry Frank. It's another deal to throw in something divisive towards you and Stella, JP. That's all it is. That's all it is. I've been going, if anybody's been going here to board meetings and ID meetings, it's me. And if anybody is close about being open to the public, it's the Board of Supervisors. You ought to go there, Mr. Aguirre. It's really bad. And I'll say one thing. I've taken Mike Kelly, and I don't mean to mention his name, because he voted for something at a time when he was defending Colab and Duggins. And he voted against the Indians in that wind, the
wind farm.
The wind farm that they had over there. It's okay, but what I didn't like was that he knew about it beforehand and the other people didn't have a chance. That was a violation of the Brown Act. And he won't accept it. And his attorney, Mike Rood, told him, no, it's okay. You did okay, because when would an attorney tell one of the board members that he's wrong? Just like back then, and I don't mean to mention, Mike Abadi was told that he could carry on and hear things in closed session, even when his attorney, Garber, told him he couldn't force him not to. That's the way it happened. So all I'm trying to tell you is that I'm going to be coming here, not because I like it, but because this openness about transparency, about direct government, about that you and JP and everybody else caused the QSA to screw up. You didn't cause to screw up. You don't cause it. The people that passed it back 8 or 9 years ago when they voted for it. They caused it because what happened is that after everything was well and done, now we have to accept the QSA. At that time, we didn't want the QSA. Now we have to accept for the benefit of the people. Not the benefit of the farmers, but benefit of the people. And this is what it's all about. It's about money. It's about putting you guys, getting you guys out there and putting people like Benson and Kuhn and someone else in there that will vote like the farmers used to before. When did the farmers and farm workers ever get together? The only time they did that was when they were working for them, you know. So to me, Mr. Aguirre, understand that even if you supported Chavez, my wife's, my daughter's husband is directly related to Cesar Chavez, okay? They know him. They know the family. And it's good that you say that you help Cesar Chavez, but the farmers don't like to hear that. They never did back then. They never will now. You know, so it's ironic that you say you defended them. It's good, but at the same time, you got a farmer with a hand on you on this shoulder. You got a farm and a farm worker with his hand on you on the other shoulder. And to me, you know, I don't know how to deal with that. You know, I don't question your integrity and all that, but all I'm trying to say, enough is enough. All this thing about transparency, meetings. Look at how many people are from the public. Nobody, and that's what you're going to have when you go to Brawley and Central and everywhere else, because they're not going to show up. It's enough for me, it's enough. Let's head forward. Let's not waste the ID's employees' time. That's where we're wasting the time in right now. And all these lies about that you and Q and JP and everybody else are pushing the QSA to benefit yourselves. That's a bunch of BS if I ever heard it. The only thing that's happening here is that as much water as we transfer out of here, more money is going to be put into the farmers' pockets, and that's what it's all about. Allocation of water to the gate so that water will be sold for not fallowing, and the money will be given to the people that are allowed to get that water instead of farming, instead of doing what's right for the people. Fallowing takes away jobs from the people. And to me, that's not what Imperial Valley was about. Thank you, JP.
Thank you, Donnie. Go ahead. State your name for the record.
My name is Yoli Cordero, and I'm from Calexico. And I wanted to thank Mr. Aguirre because I enjoyed the presentation and the presentation that the IID also made. My husband and I, we've been listening to the IID meetings on television, which they've been very, very informative. So we thank you for that. my husband and I, and people from Calexico that I've talked to in the past, we don't pay attention too much to the IID because we said it's always been controlled. It's only for the farmers. It has nothing to do with the people. But the water belongs to the people. So I see there's animosity, there's groups, like there is in every city, and there is in the county, and there is in the IID. And it's very sad to see that, but it's like that everywhere. I come from the private sector. I'm a housewife now. And I was home doing house cleaning. And I took a break. I was going to read the paper, and that's when I saw that there was going to be a meeting. And I told my husband, you know what? I'm going to go see about this meeting to see what's going on. I have a concern about the QSA, which I don't know very much about it. I hear that it needs to be negotiated, but I don't know why. I don't know what are the important points of that QSA that should be put out in the paper, because I haven't read them in the paper either. I read in the paper about this, what was it today, about the water, that they didn't save the water enough, and there's about $10 million. I go, what is going on? I mean, what are you guys not doing right? And the people in the past that sat in those chairs have not been doing right, you know? We have the same issue in Calexico, and I'm sitting on some committees, and I feel as a citizen of the United States, the citizens of this county, and as a private person, that I need to speak out because justice needs to be done for us, you know? And it's sad to see that there's farmers against farmers, you know? But while you're doing this fouling, you're causing a lot of problems to people that depend on those jobs in the farming industry. You know, Calexico depends a lot of that because a lot of people that come to work in these fields and in Pearl Valley need those jobs. So I need to go back to Calexico and say, you know what? They want to do more fouling. That means there's going to be less jobs this coming fall. That means that we're going to suffer and our sales tax are going to suffer. But no, I don't see nobody talking about that. And then I saw the presentation that this committee has where Tom Brandy's in. And I heard them, and I saw how they were going to divide the monies because they're going to save this money for fouling, 85% for the owner, 15% for the one that is going to lease the land. But I didn't see what are we going to give back to the people, because that fouling that you're going to do, you're going to save that water, which is our water. It's not your water, the farmers or the ones that are leasing. It's our water. What are we getting? We're not getting nothing. So there's something wrong in that picture too. There's a lot of wrong, and we need to make this thing right, you know? And there needs to be transparency, and all this needs to be put out. The newspaper needs to put it point by point what the issues are, you know, not just this part or that. And maybe not everything is being put out right now, but everything has to be addressed in the newspaper because that's the way we're going to get the information. And I'm also going to go to the Mexicali newspaper, you know, and say, you know what, this is going on in the IID. And the paper that is printed in Spanish for Imperial Valley, and I'm not too sure that
El Sol del Valle.
El Sol del Valle. He needs to be here. He needs to. The people need to know that, because there's some issues here. Yes, we're going to have an election in November. There's a lot of elections, and everybody wants to, you know. We don't have a representative for our district right now in Calexico. And I thought that maybe some of the people that are throwing their hat that are want to represent us in Calexico would be here. And I don't know. I don't see anybody. I don't think. So this is something that's important. It's not about, you know what, I'm going to run because I want to get this amount of income. I'm going to get benefits, and I'm going to get insurance. You know, a lot of these seats in the county, at the IID, some at the city levels, because the cities right now don't have a lot to offer. It's not just, some of these people that are running is because they're unemployed and they don't have a job and they need benefits and they're looking for their retirement. That's all. Run because you believe in something, because you stand for something and you want to help the people, and because you have God in your life. That's the number one thing, is have God in your life, because if you don't have God in your life, you can't look for each other. You can't help each other because you're only thinking of yourself. And I heard in one of the board meetings when you told Mr. Kuhn, it's all about greed, Stella. That's exactly right. It's all about greed, you know. But in fairness to all this, we also have to listen to everybody, you know. And I wasn't very happy, but I haven't been here, how you spoke to Mr. Aguirre. I felt he was being attacked. So that's the way I felt. And I go, wait a minute. This guy comes to voice his opinion, give a presentation. You know, we got to give him that opportunity.
No, Mrs. Cordero, it's not the first time he's been here.
Well, I
So-
understand.
And, sometimes I come on too strong, and I
Yes.
think by now he knows how.
No, I understand, and because I heard all that too. But still, you know, for me coming here for the first time and seeing these things going on, and I've seen everything else that's been going on television prior to all this, and that's why I wanted to come here, because we need to inform the people, and the newspaper needs to say everything fact by fact, in English and in Spanish, because the people need to know. And then we're going to decide. Yes, sir.
Would you support then us having meetings in Calexico whenever the people are off work so they can come and hear what the impacts of the QSA are going to be to them?
Absolutely. And I mean, I'll be the first one to help you put that together, you know,
The
because
impacts in Calexico are a little different than they are in Calipatria. Calipatria, they're very interested in the air quality issues of the Salton Sea. It's in their backyard, and they want to know what's going on. And the reason they're not here, because most of those people are busy out there working, trying to make a living.
right. And that's the other thing, that meetings at 1:00, it's kind of hard for the regular public to be here. You know, I'm here because I don't work, so I'm home and I wanted to come here. But the meetings would have to probably be at 5:30, 6:00, and with enough time to get people together, put it in the paper. This is what's going to be discussed. When you tell them, you know what, we made some mistakes in the past, the predecessors, but you sit on it, so you're going to represent those predecessors, and this is what's going to happen. You know, we might be owing some money, and it's going to affect your rates, and we're going to raise your electricity. You wait and see that you're going to have a lot of people at that council meeting or hall meeting, whatever
No,
you're going to
Yoli, the city of Calexico, they're going to have a town hall meeting
Yes.
next Tuesday,
Yes.
the 31st, at the fire station on Grant Street at 7:00.
Well,
Are you-
I will be going to
yeah,
that
that's
because we
Tuesday.
have
Yeah.
issues with the city.
Yeah.
So I will be there for that. And maybe that's when you can give some information of the issues that need to be discussed.
Probably
you know?
not at that time, because that's strictly for the city of Calexico. We'll probably have a meeting there at another time.
Well,
because
you
that's-
can say, you know, we'll be having.
Perhaps we
we
could
would like-
announce it at that time.
Wait,
If we set a time and date, we could announce it at that time.
and say these are the things that are going to be discussed. Absolutely.
Yeah. What is your telephone number? Maybe you don't want to. Maybe after this meeting, you can give it to me. Don't give me your number on public television.
Remember,
no.
I'm a housewife. I don't have a cell phone. Nothing.
I'll talk to you after the meeting so we
but-
can get together.
Yes, you guys have some tough decisions to be made, and don't make them because what if I don't get elected? Do what is right for the people, you know, because it's going to be in your conscience. And you farmers, I don't know what it's going to take, and I know that a lot of them already left, but I don't know why you're suing or why you guys need to work together. You know, someday we're all going to die, and God's going to call you and ask you, what did you do for me and for my people? And that's what you need to answer. Money comes and goes, and believe me, I know money comes and goes, you know, but at the end, you must have your family and a good conscience. And that is all. Thank you so much.
Thank you, Yoli.
Thank you.
Appreciate you speaking. Okay, anybody else from the public have anything they want to say?
Can I just ask one question? Have you addressed the second one of those, the water issue, about having that Diego County Water Authority. Could I say just very briefly?
No, go ahead.
Okay. When I was the city attorney of San Diego, one of the things that I discovered is that when there are developments over, I think it's 500 units, and that may not be 500, but whenever you have a lot of multifamily units, there has to be a finding in San Diego that there's sufficient water. And what was happening, what we discovered, is that there were projections that were developed and that the projections were being used even after we had the actual numbers, knowing that there was no way we could have the water. My point to you is this. I love San Diego. I was born in San Diego. My family was born in San Diego. My mother was born in San Diego. I don't want anything bad to happen to San Diego. The biggest favor you could do San Diego is to ask them, what are they doing about their recycling program? 16 years ago, San Diego was in the forefront of recycling. They have a recycling research that is cleared the recycling issue. They have the Chamber of Commerce supportive. They have the Sierra Club supportive. Everybody across the political spectrum supported the recycling. And yet they have not developed the recycling. Reclaiming their watersheds. San Diego's watersheds have been decimated. San Diego only gets 10% of its water. Imagine, how many of you would take that risk? 10% of your water comes from San Diego, 90% of it is imported, and you're at the end of the line. You have a right, because of the air degradation that you have to live through, and the other soil, the other deterioration of your soil. You have a right to go to San Diego and ask San Diego, what are you doing to improve your water independence? Because I will tell you, you will turn into a desert. You will not have a supply of water like you do today unless San Diego starts to do something about developing water independence. So the idea would be, and the idea that the suggestion is to have, even if you can't have, and council, I think council will have to research this, and I've looked at this. If you can't have a full board meeting, you might have a group that's less than a quorum on each side. But my proposal would be, or the proposal would be, that you go to and meet and have on the agenda and ask, make a presentation to us, put aside the water you're getting under the QSA, and make a presentation and let us know what are you doing to develop your water independence. Tell us where you are on your water conservation, which there's next to none right now. Tell us what the steps are to reclaim your watershed. What is your well-organized plan in the city of San Diego? Non-existent. At the County Water Authority, non-existent at the city of San Diego. And of course, you know, the smaller cities, I don't know what the answer is there. But I think that if you have a right to go and ask those questions, and you are leaders in the state, this is the state significant agency. And I think something very positive would come out, because then it would take some of the pressure off of you. If San Diego can, in the long term, develop its recycling, but people there don't want to necessarily pay for it. And that's the bottom line. And there's a little tiny program for recycling right now that has been, the mayor has just been giving some very, very minimal support to. But there is the overwhelming majority of San Diegans who do support, that is the people that are in the know, do support recycling. And I hope that you would consider having that meeting. Thank you.
Thank you. Go ahead, Donnie.
You know, as much as I hate to say it, or I shouldn't say hate to say it, I like you, Mr. Aguirre.
Oh, thank you.
I like it when you were, what was it, your position before at the city? Yeah, city attorney. You gave him hell. Yeah, not no more, but still. One thing I want to say, JP, that no matter how many seminars you have here or workshops and all that, and I don't say JP, but you're the president, is that all this is about selling water and seeing who gets elected in November. That's what it's all about. This is what it's all about. I remember specifically when Scaroni was here a few months ago, badgering the staff, and he told Mr. Kelly and Mr. Garber, and almost in point blank that once they got their people there, they're gone. And I know Kelly doesn't say nothing, and Garber doesn't say either, but I feel they know that too. Isn't it sad that somebody would run to get people that got hired by the district that went up the ranks to get fired? Isn't that bad? That's what I'm telling you, Mr. Aguirre. Listen to your people, but also listen to who you're backing up and who you're representing, because those people are mean. They're insensitive. They talk about fairness and about God, but like the lady said a while ago, I feel that way too. It's important what you do for others, because it's easy to influence and get around the people that have money and don't give you funds, but it's very hard to deal with people that are hard to get along with. And I use that as an example because to me, Mr. Kelly has done a wonderful job, and so has Mr. Garber. And so have you, Stella, and so have you, JP. And so have you, Mr. Desert and Mr. Hanks. But we need unity. We need to get together. We can't be using issues that the public needs to know this, that needs to know that, when that's going to be used as a ploy to what I said, selling water and getting new people on the board. Thank you very much.
Thank you, Mr. Ramos. Tom?
Tom Sefton, Brawley, President Menville, Directors of the Board. Also just a member of the public, not paid to be here. I'd like to second the point of view put forward by the lady who spoke a little while ago, that it really is about the public and doing what's best for the public. And I think it's pretty clear that a lot of people in the public do not know what the QSA is really about. What's the basis of the very difficult decisions that were made back in 2003 to agree to it, why those decisions were made, and what the impacts of those decisions have been and are going to be. And I do think it's very important to have the public meetings that Director Hanks suggested, whether you do it in that way or in some other way, to let the public know what the QSA really is, what it means for the public, and why those decisions were made. And some of them, there are aspects of the QSA that are probably not in the best interests of the public in this valley. However, decisions were made because they were forced upon the people of this valley by the greater political will and the greater voting power and the greater economic power of the coastal cities. But people in this valley need to know why the decisions were made and what can be done in the best interest going forward of everyone in this valley. Thanks for the time.
Thank you, Tom. Anybody else from the public?
I've got a statement I'd like to read.
Go ahead.
I think this is a summary of why we're at this point, why I keep pushing for these issues, and I'm going to put it out there. Management by political judgment. This term is used for management style, particularly influenced by outside interests of intellectuals, usually lawyers and high-ranking political figures, extremely detrimental to decision-making for our area's best interests. Loyalty becomes divided and then void to its employer. One becomes a political subdivision unto one's own self-interest. The interests of the employing organization become secondary to satisfaction of the political subdivision, self-interest, finances, and personal egos, which shapes the political judgment and also determines and limits the membership of its inner circle. Internal, localized business decisions based on management by political judgment will not necessarily be based on data and best business practices, but by political judgment at the lowest levels, elevating to upper management. The concept of only needing 3 votes is based on the philosophy of political judgment in lieu of best business practices and principled decision-making gathered in open dialogue and public participation. It perpetuates an institutional cycle that cannot exit bad decisions. Membership in the inner circles creates, in addition to wealth, the requirement for residential and career mobility. It becomes a lifetime commitment and dependency, bouncing from one organization to another upon recommendation by a peer or colleague in the inner circle. Their expertise is political judgment, and their deliverables vary, but are in the form of reports, advice, audits, investigations, and white papers, but always made to order, to falsely be considered of value. And they are also void of expectation to end repetitive bad decisions. The seasoned masters of political judgment are more appropriately called consultants, advisors, lobbyists, and lawyers. Unless these highly compensated groups provide applicable data that can be cross-referenced for validity and accuracy, leading to a conclusion or solution, then your product is political judgment, usually developed in backroom secrecy and implemented without sufficient public input or knowledge. Invariably, legal challenges or accusations of dual loyalty abound. Sunlight is the best detergent. Sunlight is the best detergent to have economics, that is, best business practices, not politics to drive the organization. Thank you.
Okay, anybody else have any comments? Kevin, what do you want to do with this?
I think this is the time when the board, as a de facto committee of the whole, deliberates and talks among itself about next steps. I mean, I've heard enough to move forward with some sort of outreach, but I'd like to hear from more than one director.
Well, I don't have a problem with, everybody talks about transparency around here. I think Mr. Ramos brought up some good points about what's going on here with the elections and QSA and et cetera. But I'm all for transparency. I have nothing to hide. I'm for, if we're not doing things correct, let's make them better. I've always been for progressive thinking, trying to move forward, trying to make the district better. The district's got issues. The district's can grow. It's grown since 1911. Gotten better over time. But the problem I have is we do not have a full board. We have a 4-person board here. We do not have a 5-person board. Come December the 7th, I believe, we're going to have a 5-person board, and whoever's sitting up here. And I think that moving forward, you should have a full board to be able to participate in making these decisions that affect everybody, because in some sense, Division 5 is not being represented on this board at this time. And so there are certain people out there of the public who don't have representation, even though we're elected from the full valley, from the water service area. And but I'm game for whatever it takes to move forward in transparency and do the right thing.
If this board chooses to hold workshops or meetings in different cities, that's fine with me. I'm game. That's what this board wants to do. That's fine. And we'll see if the folks are interested, they want to participate in the meetings, that's fine. We'll find out if there's any interest out there.
Well, I am struck by what I heard from Yoli Cordero, who I remember from years ago as a businesswoman. And I think it might be a tall order to break this down into manageable chunks where, people all of a sudden become conversant in these elaborate agreements that make up the QSA. But we certainly could go to where the people are that don't show up at our meetings after hours, and that would be a useful exercise, I think.
Yeah, I'd be interested in that, Kevin. Hearing Yoli loud and clear in the area of Calexico being without a director for representation, I think it'd be a good opportunity to hear some of this items discussed for that particular election of Division 5. And they are elaborate and detailed legal contracts and engagements and language, but we've all been digesting them for a long time. They've been making the headlines in the Ivy Press for a long time, and we should be able to sit down and discuss it with people that aren't familiar with it, that have had questions about it, and give it to them in some basic ways that we can all come and be in agreement about, and not sell it one way or the other. You know, we've been transferring water since the QSA was signed. Nobody on this board's signed that QSA, but we have been transferring water. We need the water users to volunteer their ground to transfer the water owners. The property owners. So we do need to get that explanation and that language out there and at least make the attempt. Also, you talked about Mr. Gary recommended having someone else come in and talk to us about our own policy.
Yeah, Terry Frank, I will speak with the legal people about that.
I mean, we don't need to make a decision on it tonight, this afternoon, but at least that can be brought forward and tell us what it is, what it looks like, what it would cost, how much long it would take, or if he's even interested. You know, for further discussion, it should definitely come back.
Okay. So what do you want to do, Kevin? I mean, I know we got a lot on our plate, a lot of things going on, so.
We will bring you back a plan for meetings.
Okay, that's fine.
Distance.
Okay, any other business? Okay, workshop's over. Thank you. Appreciate everybody coming.